In this video, we're going to be talking about the regulatory environment of U.S. businesses. So we're going to start by describing the nature of legal procedure. Legal procedure refers to the method by which legal rights are enforced and also the method for carrying on a lawsuit. So this can include the process, pleadings, evidence, and rules of civil or criminal procedures. Next is to discuss the nature of debtor-creditor relationships. So the debtor receives needed or wanted goods or services that may not be otherwise obtainable, and in return the creditor puts available capital resources to work and is paid for this. Both parties are likely to suffer some loss if either one fails to perform the contract as promised. A legally enforceable debt normally arises out of a contract wherein something of value has been exchanged for the promise to provide money, goods, or services, and the debtor-creditor relationship is essential to economic growth, so therefore it is encouraged and protected by law. Legal protections make creditors more secure when lending, while protecting debtors from unfair credit and collection practices. Next is to explain the nature of agency relationships. So an agency is a relationship between a principal and an agent in which the principal confers his or her rights on the agent to act on behalf of the principal. An agency relationship is fiduciary in nature, and the actions and words of an agent exchanged with a third party bind the principal. So the three types of agency relationships are buyers, sellers, and dual agency. In a buyer's agency relationship, the buyer is considered the client. So a buyer's agent has to be loyal, maintain confidentiality, be obedient, provide reasonable care and diligence, and give accounting for all funds. Similarly, in a seller's agency, it represents the relationship between the seller in the transaction, and the seller is considered the client. So the seller's agent is known as a listing agent. The seller's agent possesses the same fiduciary responsibilities to the seller as the buyer's agent has to the buyer. In a seller's agency, the client relationship is established through a listing agreement. Whereas in a dual agency, an agent represents both buyer and seller in a single transaction and carries fiduciary responsibilities to both principals. So it represents both sides of a transaction. And the mistake of an agent acting as a dual agent becomes a mutual mistake of fact by both principals, and this prevents one principal to make the other principal liable for a mistake of the agent. However, knowledge or notice due to from a dual agent is not imputed if the agent acted adversely or fraudulently. Dual agency is only permitted with the informed and voluntary consent of both the buyer and the seller. Next, we will discuss the nature of environmental law. So, the goal of environmental law is to protect the environment, obviously, and some examples of the federal law that protect the environment are Endangered Species Act, Clean Air Act, and the Clean Water Act. The goal of the Endangered Species Act is to protect plants or animals that are in danger of becoming extinct. The Clean Air Act is designed to protect air quality, and while the Clean Water Act prevents businesses or individuals from discharging pollutants into the water. Discuss the role of administrative law. So administrative law integrates several areas of law, which includes administrative rules, regulations, and procedures for government agencies and bodies, the scope of agency authority, in particular individual privacy, and enforcement powers of agencies. So that's the end of this performance element.